Hello everyone. Imagine your average morning after finishing the latest news about COVID-19 and its impact on Brexit. It makes you think, what has the EU done for you lately? Well, at the end of 2018, the EU made sure that competition authorities would feel empowered and adopted a new directive. It is called the ECN Plus Directive. While good for the competition authorities, it is not necessarily all good news for companies doing business in the Baltics. More power to the public enforcement authorities tends to translate into less freedom for market participants. So what should you know about the directive? First, the member states have to transpose the directive by 4th of February 2021. So the deadline is a little bit more than half a year away. Second, for the most part, the directive only applies to the application of EU competition law. However, in practice, member states are not likely to create different procedural rules for cases involving the application of EU and national competition law. Third, competition authorities are required to have a number of investigative and decision-making powers. To my knowledge, the Baltic competition authorities already have most of the powers required by the directive. To name a few of the more interesting powers. A, the authority has to have access to any information which is accessible to the company subject to the inspection. This means, among others, that access cannot be denied to data stored in a cloud or on a foreign server. B, the authority has to have the power to inspect private premises to search for evidence of a competition law infringement. For example, if you work for a company that encourages employees and management board members to work from home, it increases the risk that the authority might have grounds to search the homes of key personnel for incriminating evidence. C, the authority has to have the power to adopt interim measures, for example, to order a dominant company to alter its pricing before the authority makes a final decision on the existence of a competition law infringement. Leaving the investigative powers aside, perhaps the most obviously interesting demands of the directive are related to fines. A, it must be possible to impose fines in administrative proceedings or in non-criminal judicial proceedings. For example, in Estonia, this is currently not the case for anti-competitive agreements, where fines can be imposed only in criminal proceedings. B, maximum fines cannot be less than 10% of the total worldwide turnover in the business year preceding the National Competition Authority's decision. C, it must be possible to fine parent and successor companies. This means, among others, that a parent company may be fined for an offence committed by a subsidiary. Moving on from the fines, the directive also harmonizes the leniency process in the member states. To name a few of the requirements arising from the directive. A, it must be possible to submit also oral leniency applications. This requirement is related to concerns that written leniency applications could possibly be collected as evidence if the applicant has a copy of the leniency application. B, it must be possible to request a place in the queue before submitting the full leniency application. This requirement is meant to give the applicant time to gather the necessary information and evidence for the full leniency application, without the risk that during that time someone else will submit the first leniency application. We will now see what are the changes expected due to the ECN Plus directive in Latvia, Lithuania and Estonia. We will start with Latvia. Marika, the web is yours.
Yeah, thank you, Piive. Well, when I read the first time the directive, then my impression was that at least most of the demands are already included in our existing competition law. But of course, there are also some new things that that should be implemented in our law. For example, one of those relates to the calculation of turnover, which, according to the directive, should be calculated from the companies or undertakings worldwide turnover. And yeah, perhaps I could ask Jānis from Latvia to comment shortly on the situation with the implementation of the directive in Latvia, and how far is the process, and what are the main changes expected?
Okay, thank you, Marika. Yes, about I don't know, these proposals are still not in the public, but as I know, it's are elaborated now, and it's in the final stage by the Ministry of Economy, who is a policy maker, and I hope they will soon publish it, and there will be possibility to comment on these certain proposals and changes in the law. Of course, I agree that in a lot of aspects we will technically make, what to say, more precise sounding of the law to clarify about procedure rules, to clarify about investigative powers. It was mentioned about X. You need to have powers to access evidences remotely, which are stored on the servers. I think we have such powers now, but anyway, it could be clarified in the law. Talking about could there be some differences between EU procedure applied by the national competition law in the EU dimension cases or not? I think it's should be due to the reasons that usually when the case is started, it's not clearly or for 100% sure also for competition authority, is it EU dimension case 101 or 102, or is it more likely national dimension case? In some cases, it could be matter of investigation during the case. And in this situation, it should be one procedure, to my mind, applied in both kind of cases. Talking about the fines, yes, of course, it's the most substantial changes will be in this part, let's say, affecting the possible infringers. Not possible, but which will be found as infringers according to the decision by the competition authority. In this case, yes, one of the biggest changes that fines need to be calculated from and taking into account worldwide turnover, and also the maximum for for example, in dominance cases, the maximum fine we can, according to actual legislation, apply is 5% from the turnover, and it means that this maximum need to be raised to 10%. According to actual legislation, fines applied to the cartel infringements are 10%. Should we still apply this difference between maximum fines and in dominance cases and vertical restrictions, or it was previously 5%, now it will be, according to EU requirements, 10%. Should we apply or introduce higher fines, for example, 50%? It's not forbidden, it's a discretion of the national competition authorities. To my mind, yes, because cartels are mostly seen as the most serious infringements. Yes, it also applies to some changes in the cases if associations are as subjects or in a case, and how the fines are calculated in case associations are fined. In these cases, the turnover of the members of the associations need to be taken into account. Okay, that's, I think, mostly leniency procedure. We do not see substantial changes on the technical changes. Yes.
Okay, Thank you very much for your summary and perhaps what's happening with directive implementation in Lithuania. Monica, could you please take over?
Yes, thank you very much. So, well, I was preparing for this part of the webinar. I reviewed what's on the media and what's on the social networks as regards this question. And it seems to me that, at least according to the public debate, it seems that the transposition of the directive will bring only negative consequences to the businesses. The businesses are afraid of the huge penalties that may be calculated from the worldwide turnover because they might increase 10 times. They are worried that this may result in bankruptcies in Lithuania. Some are also worried that the Competition Council in Lithuania will get more powers, even though it is already quite powerful. So I just wanted to ask Šarūnas to elaborate a bit more. How do you see the main novelties that the transposition of the directive will bring to the businesses in Lithuania? And what's your advice? How could the businesses prepare for this transposition? Thank you.
Well, I think the best preparation, thank you, Monica, the best preparation is not infringe competition law, period. And then, who cares about the amount of fines? On a less serious note, I think what happened in Lithuania was quite interesting in that the directive has already been transposed to some extent, as a first step already last year. Because, for example, one of the major changes that went more or less unnoticed, I would say, was introduced earlier, not with the current package. It's the structural remedies that could be imposed as a sanction for infringement. So we already have that because of the amendments that were made and are already applied. They are in force now. Now the current package transposes whatever remains, and there is nothing major in there, as groundbreaking. I'm not really sure whether this fear of higher fines is very substantiated, because what will increase is just the reference turnover to calculate the upper limit of the fine, because the upper limit of the fine has always been 10% of the turnover. So the fact that it's worldwide turnover, it may be relevant in some cases, but not necessarily that often. Plus, the fine is calculated in relation to the taking the turnover related to the infringement anyway. We do not calculate the fine in relation to the global turnover as a first step. This just acts as a security measure for the companies so that fines are not too big. When it comes to more powers to the competition authority, I don't think that the transposition will give us more powers. Some things have already been mentioned, like access to online or to the information stored in the clouds, for example. But other than that, we have already pretty significant powers before. I don't see many changes here. Then there will be some provisions of a more, well, declaratory nature when it comes to independence and funding of the authority, because we had our independence before. There will be some wording added in the law. I think more important, there will be some wording added on the funding, on the sufficiency of funding. Whether that would translate in practice in more stability when it comes to funding, we will see. But it will be good to have this wording in the law. And when it comes to the law itself, to the package that is now prepared for the transposition, it has already passed the Cabinet of Ministers, and the parliamentary committees have already approved it. and the Parliament has already approved it on the first reading, if I'm not mistaken. So now it can be adopted basically anytime, whenever the Parliament includes this draft bill into its agenda. So we can transpose the directive as soon as this summer, in the best case scenario.
Thank you very much, Šarūnas. It is clear that businesses have to adhere to the rules of the competition law, and it seems that the authority in Lithuania already has quite significant powers, and the transposition of the directive will not change much. So maybe these fears are, to a certain extent, not that serious. Thank you very much, and I give the floor to my colleague Pibe to continue the discussion on the novelties in Estonia that the directive will bring.
Yes, thank you. The changes in Estonia will not affect only competition law, but also personal data protection and financial law. This is due to the fact that in all these three fields of law, the EU requirements for finding possibilities do not fit in the current legal system in Estonia. So the current plan is to reintroduce administrative fines to the Estonian legal system to comply with EU requirements. The Ministry of Justice is currently working on the draft law on administrative fines, as well as draft amendments to the Competition Act. The Ministry hopes to have the first draft on administrative fines ready for public consultations during this summer, and the draft amendments to the Competition Act this autumn. But let's take a closer look at some of the major changes that we already know we can expect in Estonia. First, arguably the biggest changes are related to fines. The ECA, which is short for the Estonian Competition Authority, will likely start imposing fines and administrative proceedings. The EU believes that criminal proceedings lead to fewer and lower fines, hence the requirement that fining for competition law breaches must be possible outside criminal proceedings. The most painful changes are related to the level of fines. Currently, only fines for cartels are capped at 10% of the turnover of the relevant company. The ECN Plus directive, on the other hand, expects the cap to be not less than 10% of turnover for all anti-competitive agreements and abuses of dominance. The changes concerning fines do not stop at this. Currently, the maximum level of fines is tied to the turnover of the legal person who breached competition law. In the future, it should be tied to the turnover of an undertaking. Usually, companies within the same corporate group are considered to be one undertaking for competition law purposes. This means that companies that belong to large corporate groups will feel the biggest impact of the switch from the turnover of a legal person to the turnover of an undertaking. Another change relates to the business year used for fine calculation. Currently, it is the business year preceding the initiation of criminal proceedings. It should change to the business year preceding the decision of the Estonian Competition Authority. The effect of this change depends on whether the turnover increases or decreases during the time of investigation. On top of changes related to fine levels, the ECA will be released from the obligation to identify a natural person who committed the breach. It is one of the changes that will make the competition authority's life easier. At the same time, it will take away one of the defense arguments from companies under investigation. Market participants will also not be overjoyed by the change that allows the ECA to impose fines on parent companies and successors of companies who have breached competition law. This means, among others, that insolvency of the breaching company is less likely to save the group from paying the fine. There will be numerous other changes, but I believe we covered the key ones. The best way to prepare for the changes is to ensure, like also the Lithuanian Competition Council representative said, is to ensure that all your agreements and activities are in compliance with competition law. If you have not done anything illegal, the changes in the level of fines and the procedural rules will not have a major impact on your business. If your company has internal competition law compliance guidelines, the guidelines will probably need updates once the new procedural rules are adopted. Also, if you are mapping the company's legal risks, the risk assessments related to competition law will need updates as the maximum fine levels will go up and it will be arguably easier for the competition authority to impose fines. This was a summary of the changes expected in Estonia. I will now give a chance to the Estonian Competition Authority representative, Juhan Põldroos, to share his views. Juhan, could you tell us what are the changes that the ECA is looking forward to the most?
Okay, thank you. As we don't have a specific law yet on the table, so I can generally speak about the kind of wider context of the changes that we are undergoing. Well, the thing is that in Estonia, the way competition offences are proceeded has been historically rather unique in the context of other European countries. In particular, we are one of the very few countries that have used the criminal or quasi-criminal system for competition law offences. As I remember correctly, there have been 5 other countries in the European Union have more or less the similar situation, and all the other countries have used the administrative system or the civil system, and that is something that we are also trying to introduce now. Now, the problem is that indeed the level of proof or the burden of proof for a number of reasons in the criminal system is much higher in these countries, and then there is a trade-off that if you have the higher burden of proof, if it is more complicated for the authority to bring cases forward, then on the other hand you have less cases, you have less fines, and that is what the European Commission saw, that actually that kind of systems, well, you can say that they are not working, but they are not working as well as the administrative systems, and hence the ECN Plus directive. The directive doesn't say outright that you cannot have criminal system, but there is a number of requirements there that run contrary to the very fundamentals of the criminal law. For example, the right of self-infringement that is provided a completely different way than it is right now in Estonia and any other criminal system and so on. So all that means that Estonia is one of those few countries in Europe where you really need the seismic changes to go along with a new directive. We don't have any administrative fines as a kind of instrument, our legal architecture at all, and this has to be done from the scratch. And this is a very huge process. It is very time consuming, and that is the reason that as a process, we are not there yet as our colleagues. We don't have specific laws yet on the table. There is a very ambitious timeline set by the Minister of Justice. It remains to be seen whether it is doable in the first place. What we expect from the law. Of course, we are expecting a more efficient procedural systems that we have had until now. And by efficiency, I mean, as with any legal system, it is not just a question of the legal standards, it is also the question of efficiency. And one thing that has bothered us is that the current system is terribly resource consuming. We want to see something simpler that at the same time meets all the requirements by the businesses for the rights of defense and so on. For example, to give you a very small kind of simplistic example, normally if a competition authority deals with an offense, then it does a kind of cease and desist order, and once in a while it also wants to fine the company. And now in many European countries, authority can do the order that stops the infringement, and if it wants to fine the company, it just writes the document a couple of pages longer and says that I'm going to fine you also. Well, it usually is not that simple, but that is the general direction. While in Estonia, if we want to also fine the company, we have to carry out the whole separate procedure, which is way more complicated than the initial procedure. So we have those double procedures with which we actually think that this is a waste of public and private resources, and there has to be a better solution for that than to basically proceed the same thing 2 times all over again. So for us, saving our resources to be more efficient is a very important goal here, especially having in mind that the Estonian Competition Authority is a very small authority. Even if you take into account the size of the country, we are, as far as I know, a couple of times smaller than the Latvian and the Lithuanian authorities. So being a small authority and on the other hand, having a very resource-consuming way of procedures, it has put some stress on us. Now, indeed, as far as we have to build that thing from the scratch, it is a bit difficult at this stage to give examples of the specific changes that are going to be made. It is going to be a very fundamental change. For those of you who are lawyers, who probably understand what is the difference between administrative system and criminal system. It is not just the difference between some elements over there. It is the kind of way of thinking and the way that the court operates. It is a whole different system. For example, okay.
I apologize, but I have to interrupt you now because we are short of time. If the time allows, maybe we'll get a chance to comment also in the Q&A session. But thank you for the overview. I would just add that I hope that the people working on the draft laws also consider the rights of the companies under investigation and don't focus only on increasing the rights of the competition authority. But this here closes our second topic, and we can now move on to the Q&A session.
Yes, hello, this is Kaupo here again. I can actually perhaps continue with the Q&A session there where actually Juhan ended. Of course, let's say in Estonia, the ECN Plus directive and its transition, it has caused a lot of turbulence, and let's say there is a heated debates about its impact. And mainly the concerned parties are the private sector, who are concerned about their rights and, let's say, the ease of being punished, which is not necessarily a good thing always. But actually, although I'm quite triggered on that topic, or it's very easy to trigger me, but in this respect, but I would like to actually hear from your side that where do you see the biggest obstacles or biggest challenges in either transposition of the ECN Plus directive or actually its implementation in Lithuanian case? Perhaps let's say, perhaps I can start with Juhan. Where do you see risks, or what are the challenges? Is there some more powers that are still missing from the ECN Plus directive? So what are your thoughts on that? Juhan, you are on mute. I'm sorry, Juhan, you're still on mute.
Okay, sorry for that. The directive is not worded in having in mind the system with a criminal law. It is more or less worded with having in mind the administrative systems, and that means that as we have to do it from scratch, all options are on the table. We can actually draw all kinds of powers to the competition authority, and this is a matter of discussion. I think what are going to be the most heated debates about are the rights of self-infringement. This is something that right now the companies have a very absolute right to remain silent in Estonia. The directive says that that cannot be that way. You have to have at least some mandatory information that you have to go bring to the authority. This is a major change, and this of course is going to be a matter of debate. For the competition authority, internally it's going to be a huge change for us, because the criminal law is not all that bad. It is actually quite good for hardcore horizontal cartels, the worst kind of price fixing, the secret cartels. It just doesn't seem to be working for everything else. Now the issue is how do we remain that efficient also in case of hardcore cartels, where we can right now use all the tools that are inherent to criminal systems, wiretapping and that kind of things that Latvian and Lithuanian colleagues cannot use. We can use also the mighty brain power of the prosecution right now, but we have to start doing ourselves and so on. So there is a lot of challenges.
Okay. But Šarūnas, let's say you have already this experience of applying majority of these measures. Let's say what are, let's say in a very brief manner, what advice do you give to Estonian authority in their preparations?
Well, don't be afraid, Juhan. It's not that bad. I mean, if you could live in a world with criminal enforcement, the administrative enforcement in many ways will be similar or a bit easier. And I think why it is important to have an administrative enforcement system is that allows you to be in better control of the policy of enforcement, because you're not dependent on the external parties, on the prosecutors, on courts that much, because you are the owner of the case, of the administrative case, and you can issue decisions. But having said that, in our law, the administrative procedure is still fairly strict. So the lessons that you learned in Estonia with criminal procedure, I think, will be very relevant. And you still have to ensure due process. You still have to respect the rights of the parties. You should have to deal with the case documents in proper manner, and all these things, they will be there.
Yeah. Okay, that is really, let's say, reassuring to hear. But while we are already talking to you, could you perhaps answer one of the questions coming from the audience? Let's say on these hearings in video formats. Let's say quickly 3 tips how to organize a good video hearing and how to attend properly in a video hearing. Let's say time is pressuring, so in a rapid manner. Yes.
Okay, I think have a good equipment and stable internet connection, because that's essential. Without that, you will fall. Well, start organizing early because it requires more preparation. And for example, even when you start registering the participants for the meeting, start early in advance, because people can have some technical issues and so on. So leave yourself at least 1 hour for the registration of all the participants. You can have more. And then be in control of the process. Do not allow, and I'm speaking here now as a chairman, do not allow people participating in the meeting to speak all at once, because that may work in a live meeting. Even that creates a mess. But online meetings, you have to be very disciplined, and of course it requires cooperation and goodwill from everyone involved.
Okay. Thank you. That's useful. But now, actually, one intriguing question for all authorities, and perhaps Jānis could start the opening. Let's say, are authorities more likely to raid employees' homes because of working from home policies? Is it just an hypothetical risk, or should we change our locks on our doors to defend ourselves against the authorities visiting my home, your homes? Please.
Of course, we, as I said previously, there is certain tactical risk how we assess or how we manage the investigations, and in these cases we carefully assess where to go. Of course, we are not going to the premises where there is nothing, and due to that, in certain cases, due to the reasons of that most of the people are working remotely, we will, in any case, according to judicial review, which is done before such authorization is received, may in certain cases conduct investigations also downrange in the home. We did it also previously in certain cases, but it is very carefully assessed from our side in which cases it could be done, because it's higher standards for the proof to.
Okay. Yeah. Thank you. Yes, I'm sorry for making jokes about let's say intrusive things like raids at people's homes. But still, the working at home is a new policy. And let's say, Juhan, do you see any changes in Estonia in that respect? Let's say companies, they used to be in their headquarters. Now the companies are everywhere. So do you see a kind of risk or potential of increased visits, knocks on home stores?
Yes, of course, there is a complete logic in it. If one wants to find evidence, one should go where the evidence actually are. And if people are working from home, then naturally you should go there. And I think that is one of the peculiarities of the criminal system, that in that system, outside competition law, in any other field of criminal law, the going to people's homes is not that strange, or there isn't such novelty into it. And that also means that the Estonian Competition Authority, now Dawn Raids, we actually have gone to people's home. It's nothing new for us. And I think you're right. If people work at home, if the evidence are at home, then it's natural for the authorities to go there.
Sounds scary, but a bit logical. How does it look from Lithuanian point of view? You are on mute, Šarūnas.
We had these powers already for some years. We have never applied, and I think as with any Dawn Raids, we take great responsibility for taking the decision to do a Dawn Raid, and of course we'll have to get approval from the court, and that includes Dawn Raids of private premises. We realize that's a disturbance of people's lives, and we will not take these decisions lightly. But then again, all the Dawn Raids are based on evidence and on need. So if we think, if there is a need to carry Dawn Raid the homes, and if we believe we may find good evidence there, we'll do that. That's one of the tools available.
Okay, but thank you everybody for these questions. Time is pressuring up, putting pressure on us, and unfortunately we cannot take any more questions and answers. Some of the questions have been answered in the Q&A section there as well, and then with the others, we hopefully also after the seminar, Soren and people will take care of responding to them. So check in, please. So, but thank you everybody. Thank you for the speakers, for guest speakers. Thank you to the participants of the webinar. And let's say I think it was interesting to listen for me. I got a new understanding. I got also kind of understanding that the Baltic countries, and although the laws may be different, the Baltic countries' approaches perhaps are not that different. First of all, let's say it's good to hear that actually we all hope that the coronavirus will be a thing of past, but we have learned a lot from that, mainly the way we work. And that's actually the video hearings. That is something that most likely would be highly welcome here in Estonia as well. And I'm sure Latvian colleagues would love it as well. At the same time, working from homes, yeah, it's logical that if the companies move away from their headquarters and they actually businesses start operating from people's homes, then it entails certain risks for those homes as well. But as always, the best advice is don't breach competition law, and then your homes are also safe. And last but not least, it looks like the world has not really changed. There will be no zombie apocalypse. Competition law shall be still enforced in a kind of very familiar manner. And hopefully also the turbulences around the ECN Plus directive, mainly here in Estonia, they will find a nice compromise where everybody are more or less happy, because what we heard ultimately also from the other authorities, that actually rule of law is still something that our countries and the European Union considers really important. So hopefully we will, after a year or two, we can share good experiences from Estonia in that respect as well. But then many thanks to you, and please give us feedback. so it helps us to make a better seminar for you next time, and talk to you soon. Goodbye.